Right, welcome. My name is Richard Ansar. This is Kevin Griffith from the Equitable Way. Welcome. Just wanted to shoot this quick question and answer video in relation to understanding court process for both being a claimant and a defendant, and also regarding the UK Lien workshops that we've got going on and planned for March and also for the rest of this year. So welcome. And if you're wondering why Kevin's got something in his ear, he's just I'll let Kevin explain for himself.
Yeah, I'm just recovering from an ear infection. My ear's quite sensitive, so that's why I've got the cotton bud in my ear.
Yeah, so I know what you'll be thinking. You'll be looking at the camera and that's going to distract you. So hopefully we'll get it out of the way. Right. So first of all, I wanted to just answer a couple of questions regarding the UK Lien in regards to being a claimant. Obviously we've got a couple of webinars that's already available for you to watch. If you don't know what a lien is, then you can spend time and watch those two resources, which will be very, very useful for you. But I had one question that was asked, and I'm going to read it out from one of our trust students or coaching students. And it says, "Hi Richard, I've seen your email on a lien seminar and I'm interested, but can you please explain how this course fits in with trust knowledge? I have an understanding that trust and equity is the path to go down. How do the liens enhance the trust knowledge methodology?" Which is a really great question. So what I would do, first and foremost, trust in itself is one thing in terms of, on the course, you'll talk how trust works to the administration, you understand the enforcement side of trust, in terms of understand how equity plays a role to compel the trustee as a beneficiary. And then you've got the litigation side. We do talk a lot about courts and how to put a claim against a trustee for unconscionable conduct. However, any information you can get to understand how the court works will be in your favour, because you need to understand, obviously we talk about what rules and where the court rules are and how to find them, but things change as well, and it's nothing better than having an expert, especially like Kevin, who's in the court weekly, helping clients all the time and has a full understanding of equity as well as myself, that can help you to deal with situations where you may need to make a claim against a trustee for a breach. And we will be going over the Part A claims. So if you wanted to ask a specific question, which is another reason about the course, why we teach these sessions in a group format as opposed to one-on-one. We have a lot of people coming to us wanting our help, which is fine, but our time is not free, and a lot of people in a financial situation where they can't afford lawyers, and we don't really want to be in a situation where we're putting people under unnecessary pressure financially just to get a bit of guidance and coaching. So that's why we do the workshops and also have courses on for memberships and things like that, so that it's affordable and accessible. All right. So the benefit of coming to one of these workshops is that you've actually got our time, because we don't have huge groups of about 50 people. Normally it's about 5 to 10 people, maybe 20 people at a maximum, where you can ask direct questions specific to your cases, and we will give you the best answer that we can. No different to if it was a one-on-one situation. Obviously, if it's a huge case, then that's different. But if it's one that you're already halfway through, or you just need some guidance, you want to know how to deal with it, or you're not getting the results you're looking for, you can ask direct questions and utilise our time efficiently to get the answers, and then have a full understanding of what to do next. And that's going to be your best option outside of having us on a one-to-one basis for coaching. So Kevin, I don't know if you'll answer any more questions specific to the equity side, but that's the reason why it's useful, and anyone who's on the trust course should benefit. But go for it.
Yeah. So that's in terms of the question that was asked, the trust and equity knowledge can be useful in regards to the lien setup, in that, as Richard said, you get an understanding about the court process, but even more importantly as well, you get an understanding about the concept of clean hands as well, because under the lien process we will go through clean hands. And when you're making a Part A claim with trust and equity, that concept is even more important for you to understand. So whereas the UK, the lien process may be distinct from trust and equity, it is interlinked in certain areas, in that when it comes to court, you need to be able to navigate the process, and definitely when it comes to the issue of clean hands, they both are relevant to each other, I would say.
Absolutely, fantastic. So hopefully that answers your question specifically for any students on the trust course. If you have to get to the court side of things, at least you can A, ask the questions, and B, know what to do to instigate that situation as well. In general, why I wanted to talk about what you're going to get from the course beyond what the sales page says, but being a claimant is completely different to being a defendant, and that's why we decided to offer training or coaching on the claimant side and on the defendant side. And I'll come to the defendant side in a minute. The main thing to understand is that as a claimant you have the upper hand, but most people still get beaten up in the courtroom even though they come in as a claimant because they've done things wrong, or the process hasn't been followed through correctly, or the procedure hasn't been done correctly. And when people ask us questions, especially on the first workshop we did in I think it was November last year or October last year, it became apparent that even though they were very close to getting the right answers, there were still blockages as to what to do or how to stop cases from going ahead, or whether they're in the right track, or should I ask this type of question, or how can they address certain scenarios. And just having someone else to sit on the outside and give some guidance, it really did help a lot of the students that were there on that day, and they left liberated and happy. So we want the same for you as well, and the reason why I've offered a significant discount on this particular workshop, A, because I told you I quit my job, and I'm really happy about that, and I want to celebrate that, but also to give you the opportunity to make the most of this situation, because I don't think I will be doing it again after this particular workshop. So it is actually in your best interest, if you want to take advantage of the situation, do so. There's people who know they won't be there on the weekend, but they pay because they've got the replay for the 48 hours, and they'll have access to the recordings for as long as they need it when it's available via the membership. So you can't lose on this particular scenario. Even if you can't make it physically for the weekend, you can still get access to that information for your benefit moving forward. And if you have questions you want to ask, and you can't make it, you can email me as well, and I can make sure those questions are addressed as much as I can, so we can help you as best way as possible. Alright. The other thing I wanted to really go through now is about the lien defence side of things, because as much as being a claimant I've already covered that quite a lot. Most people get beaten up because of the defendant. I've got situations where they've got a court case, for some reason there's been some kind of a litigation, there's been some kind of dispute, it's not been resolved, a bank or some other claimant has made a claim against you, and then we respond, but we don't respond correctly, and then we wonder why we get beaten up. Even though we're right in principle, you've got to understand how the court operates, and excuse me when I sneeze, sorry, live accordingly. So Kevin, can you give me a bit of an insight why you believe that being a defendant and dealing with a court case, especially because you're in court often, is imperative, as well as obviously being a claimant?
Yeah, it is. But the thing as well to look at is that a fundamental aspect of it as well is, as a defendant, you have to also know that the presumption is that you're guilty. Your hands are unclean, and that's the presumption that the court have. So that's a hurdle that we as a defendant, that you have to deal with. So the claimant has brought a case against you for whatever the reason is. The presumption is that your hands are unclean. So you have to deal with that first, whether it may be making a counterclaim, or just slowly within your defence asking questions. So it's very, very important to just first and foremost know that the presumption in the legal system as a defendant is that your hands are unclean. So that's the first gap that needs to be breached, which is very imperative.
When you say presumption, in terms, because obviously if you're presumed guilty, that's a trustee language. If I put it into the trust context, in other words, you're compelled to get back in line to do what you're supposed to do in the first place. So that's why it's important to know how do you change that around in the defensive stance. And obviously, people have talked about the free man route and getting judges on taking their rights away and all this kind of stuff. If you're the only one who that works for and living that life and you're not worried, fine, you don't need to come on the course. But anybody else, I know I don't know anybody like that, then it's important to understand how that works. And just a simple process of knowing how to ask the right questions, not leaving things under the bed or not opening envelopes when you need to deal with situations, or even if you're using a private process to deal with certain situations, if it's being ignored, how to get that in the public without divulging what's gone on, or being seen that you're mad because of what you're talking about, is not going to be utilised against you either. So that's very important.
And the other thing as well, even though you may be the defendant, you will have an opportunity, or you should have an opportunity, even before a claim gets issued, for you to be able to ask questions to purge your so-called unclean hands anyway, which is very, very important. So as Richard said, it can be the case where people, they don't answer, they don't open their letters and they ignore things, and that can be very detrimental, because as I said, as a defendant, you will or should have the opportunity to be able to raise questions before even legal proceedings are issued, which can take away that presumption of guilt against you, and now put, as I call it, the hot potato back on the claimant to now address these questions that you've brought up.
Absolutely. Another point with being a defendant is the power of a counterclaim. A lot of people don't know how to utilise that properly, what to do, how to draft. Okay, we have this language that we utilise, which is not plain English, and really you've got to learn how to convert what you know into plain English and ask it in the right way, such that whoever's reading it can read between the lines of what you're getting to, without you divulging or putting yourself in a situation that could be compromising yourself. Okay. And drafting is extremely important. You just need to know how to just draft a simple statement, and understand what the rules are, what a judge is looking at to make a decision, with something like the balance of probabilities that we talked about. If you've heard of that before, he's aware that the defence claimant, well, who's more likely to be giving me the truth for me to make a decision. We talked about in the course, the initial claim lien course, about limiting the judge's discretion, which if you're going to attend the workshop for being a claimant, it's even a bigger deal as a defendant. Understanding how to establish facts. Truth doesn't really matter in the courtroom; it's about the facts and who's got the most facts to make sure that the case looks like the one that's going to be winning, or the decision will be operating according to for your favour, not somebody else's. And even as a defendant, you can turn a case around that you can win, or buy yourself more time. Say it's a mortgage situation, where you're the defendant by default, and you have to deal with certain things because the bank maybe haven't been as forthcoming as they need to be. There's things that you can do, and as long as you get to it in good, timely fashion. Regardless of the time scale, to be fair, even it could be a day before a court hearing, day before a repossession is supposed to be executed. Things can still be done to buy you more time and to even rescue your home. So it's imperative you understand that.
And just to add to what Richard said, I've personally been part of cases where defendants have been successful against claimants, which we will obviously elaborate more on the lien course. But although, as I said before, the defendant, there is a presumption of guilt, that doesn't negate the fact that defendants can be successful and are successful in some cases.
Absolutely. Fantastic. So I will be releasing more information about the defence side of things very soon, because obviously that course is actually taking place, the first one, on I believe the 10th and 11th of March, which is about a week from today. And obviously if you're watching this recording after that date, then there'll be other opportunities to attend as well. We're planning to do this as a series throughout the year, but the main reason why I'm elaborating on this particular weekend and for next weekend, because of the discounts that we're offering as an incentive to yourselves to attend the workshop. All right. The other thing I wanted to clarify as well regarding the lien course on the claimant side of things is that the way we're going to teach it is start from very scratch. So you don't need to be an expert in court. You may never have been to court before in your life, but it may be something you can help someone else with, or you may need it because of the situation you're dealing with at the moment, where you feel it may go down that road. And it's imperative that you have an understanding of when letters are written to you, notices have been sent to you, what to do. So we start from the very bottom, from the top, but we're starting from scratch, line by line by line, precept upon precept we are going to cover. So that's how I teach, how we teach anyway. So when we get to the more advanced stuff, you're on board, and we make sure that everyone's on board for that purpose. We don't deal necessarily much with magistrates' courts, but the technique and the mentality is still required to understand how to deal with magistrates. If you need to look for information to circumvent the situation, you still need to know how to go about doing that, how to represent yourself if you've got to go in the courtroom itself. So it will still apply to magistrates' courts, maybe indirectly, but it will still have some bearings on that as well. You will, if you're dealing with bailiffs and they're starting to write notices to you, again, we've had, especially Kevin, had significant results where he sent bailiffs in to claim on behalf, in terms of perfecting a lien, how to execute that lien if you have claims against other people or companies, corporations who have done you a disservice or injured you.
And they've been monetized.
Absolutely, they've been monetized, so you've actually got funds in your hands now. So literally, if you imagine the program can't weigh, because it can't pay, won't pay. Yeah. But the shoe's on the other foot, so to speak, and then you can utilise that for your own personal benefit as well. So if you've been ill-treated by a bailiff or a credit agency or something like that, and you know that you've got proof to confirm that the case shouldn't have been that way, and they shouldn't have taken things from you, whatever the situation may have been, then you can restore that situation as well. And again, that's information that we will cover in the course, if that's something you're looking for to learn as well. All right. So I don't want to labour too much. I think that's enough for things for you to make a decision. I'm looking forward to seeing you on the workshop this weekend, and if not, in future workshops. I'm just going to shut my email down, but it's making lots of noise. And other than that, thank you very much. If you have still more questions after watching this as well today, then feel free to email me directly. You have my email address. I'll just get you anyways, admin@WGE revamped, that's revamped.com. Alright, thank you very much.
Thank you.
Cheers.
Bye.